All right.
Welcome everybody. Welcome to the second edition of 20-Minute Talks. I'm glad that you're all here. I'm especially glad that Umberto is here because I feel like if anything goes wrong, he's much more technologically advanced and suited than I am. But for those of you that may not know Umberto, I am actually going to read his bio. So Umberto Mass is the president of Commercial Collection Agencies of America. He earned his Bachelor of Arts degree from California State University. And in 1986, as a summer job, he took a collector position at a firm called LC Financial. He wanted to learn the art of negotiation. He was promoted to the role of account manager, and he directed the handling of debtor accounts along the East Coast region, which involved communicating with clients and forwarding attorneys, as well as taking over the training of the collection staff. In 1996, he assumed the role of general manager, overseeing the daily operations of LC Financial. In 2004, LC Financial was purchased by Creditors Adjustment Bureau, and Umberto oversaw the integration of LC Financial operations with those of Creditors Adjustment Bureau. Today, Umberto continues his summer job as the general manager of Creditors Adjustment Bureau, overseeing the operations of the collection, sales, administrative, and legal departments. So Umberto, again, thank you very much for being here, and I will turn it over to you, and we can continue this party.
All right, well, welcome everybody. I'm glad that everybody's here. It's my pleasure to introduce Peter Helt. Let me just go over Peter's bio. Peter Ramsey Helt is a managing member of the law firm of Bailenson, Kudish, Greenberg & Helt, LLC. The firm has been handling commercial collection and creditors' rights cases for more than 80 years. Peter has 35 years of experience focusing exclusively on these types of cases. He actively practices in Washington, D.C. and Maryland. Peter played a major role in drafting the rules used in Washington, D.C. to process collection cases. His insight dramatically improved the speed at which collection cases now move through the court system. He is the former mayor of Mount Airy, Maryland, a suburb of Washington, D.C., and he is an active member of the Maryland D.C. Creditors Bar Association. Peter has recently been appointed to the Independent Standards Board, which promulgates the certification requirements and reviews the governing documents of Commercial Collection Agencies of America. So everybody, please welcome Peter. Peter, thank you for being here.
Thanks, Umberto. Thanks, Annette. I'm supposed to talk about Maryland and DC today, so I'll get rolling since we're already about 15 minutes into this 20 minutes. I'll start with DC, just to give you kind of a brief rundown of what's going on in the District of Columbia. It's kind of a little unique in DC because DC is not a state, so their court system is actually kind of a federal system, so it's a little odd. Basically, in DC, their big dividing line is $10,000. Below that's your small claims. Above that's your what they call civil. I really currently don't recommend anybody file anything in the small claims jurisdiction. It's kind of a mess right now. They're still trying to sort things out since COVID. One problem that you have in small claims is the perhaps constant need for a witness almost right away. They treat small claims like okay, there's no answer. We show up for the small claims hearing, and if the other side is there, we're supposed to go to trial. So you can see the real problem with that. There's no discovery, there's no answer, they don't have to file, they just show up. And if they show up, then we're expected to move forward. So I don't really recommend that. Now, the nice thing when you get to the civil cases, which is over 10,000, is except for trials and basic hearings and things, they're still virtual, which is why I have this headset and this camera, which is really nice. It saves a lot of time, but it is what it is. Basically, one of the things I wanted to touch on is filing. If you file in small claims, it's going to be about $45 plus whatever your service of process is. If you file in the civil, over $10,000, that's going to be $120, not including the actual service. And service can be anywhere. You just don't know how hard it's going to be to serve, how many times you have to reissue. One problem we deal with on the commercial end is a lot of times resident agents don't make themselves available. So we have to serve the government, and the government charges for that, process service charge for that. So service can get fairly pricey. One problem we have currently in DC is they're not following their rules. Rule that we run across a problem with all the time is when a debtor does not file an answer to a complaint, the rule says the clerk must enter a default. It doesn't say should, it says the clerk must enter a default when the defendant doesn't file an answer. They're not doing that. They're waiting till the case comes up and you've got to go to a hearing before a judge. The judge will enter a default, and then he'll set the case for a couple months out, and then you'll have a default judgment hearing. That's not the way the rules are written. That's not the way it's supposed to happen, but that's the way it's happening in DC right now. There was a battle at some point going on between different people controlling different parts of the different clerk's office in DC, and this is how they're getting around it. So, that's DC. But as far as civil cases, it's really not a bad place to file a civil case, the ones over 10,000. You will get through this courts. It'll be a little bit slow, but you'll get there. Now, collection into things. That's where we all like to get involved. Typically, levies, till taps, things like that, they're not typically done in DC. Problems being DC does not really have a sheriff's office or something to do those. You have to use the U.S. Marshals. And the U.S. Marshals are not particularly responsive. You have to jump through all these hoops to get them to do anything. You have to post bonds. You have to get special orders. And then you still get marshals. I had a marshal call me up one time on a till tap, and he says, because the till tap said seize the cash receipts. And the marshal calls me up and says, do you want the money or do you want the little receipt tape in the cash register? Okay. These are not, these are not guys who really, really are particularly good at going out and doing this. So we don't, there's not much levies going on in DC. Now on the garnishment end, DC garnishments are fairly reasonable. It's going to be about $26 and plus service for each bank. The problem in DC is garnishments can only be issued on entities that have addresses in DC. And when we get to Maryland, we'll see we don't have that same problem. But, you want to garnish a bank and they don't have a branch in DC, you really can't go after them in DC. They got to have a branch in DC you can walk into and hand papers to if you want to get there. The other problem with the DC garnishment, it is one shot, one day. So when the garnishment hits, if the guy's got $10, they file an answer for $10. Even if he has $1 million in there the next day, you get $10. That's kind of a real pain. On the DC side, as far as foreign judgments go, they take foreign judgments very well. So if you've got a judgment coming from another state, DC will take it quickly. It's fairly easy to file, and then you can move forward with your execution. But the execution in DC is okay. There's not a whole lot you can do. You can try and do oral examinations on debtors, but it just doesn't work much. If you send the marshals out to issue the oral examination subpoena, the marshals, they never serve these guys on the commercial cases. I mean, they just never do. There's no incentive for them to go out there. They'll go out at like 7 a.m. or something on their way to work. Well, the business isn't open yet. So we don't do a whole lot of oral examinations in DC, but we do some. We will take shots at them. Let's move into Maryland. I think that's where things work a little better. Downside in Maryland is nothing is currently virtual. You're showing up for everything. If there's going to be a trial, the witnesses have to show up. I actually had a trial about 3 weeks ago where the debtor was in Chicago. He filed a motion requesting to appear virtually, and the court denied it. So they don't want anything to do with virtual in Maryland. So your witnesses are going to have to show up if we're going to a trial. Now, another issue we have in Maryland is anything under $5,000, which is a small claims case. The legislature has recently removed our ability to do debtor examinations in those cases. because they were worried about debtors getting thrown into debtor's prison, which we all know is not really what's going on. But that was the concern with the legislature. So any small claims cases, unless you know where these people bank or something, you can't bring them in for an examination to find out that information. You can't send them interrogatories. You can't send them anything. And it was kind of an interesting story about how that took place. A couple of years ago, the Maryland legislature tried to take away the ability for the courts to basically issue um, body attachments when debtors refuse court orders, because that's what happens. The debtor doesn't show up for an oral examination, and the judge will issue a body attachment, which is basically telling the sheriff to go out and arrest the person. The courts weren't real happy about that. So the courts basically said back to the legislature, look, you do not have the authority to remove contempt powers from the court. You don't have that power. So what the legislature did the next year is they came back and said, okay, you still have your contempt powers, but we're going to remove the ability to do debtor examinations. So you never get to the issue of your contempt powers because you can't have the debtor come into court. And so that's where we stand on oral examinations. Fortunately, it's only in small claims cases right now, which is 5,000 and down. The Maryland courts are largely divided into two categories. There's district court, which is small claims and regular cases, and there's circuit court. District court's 30,000 and down. The difference between small claims and regular cases is not much. Same courthouse, same judges, same courtrooms. It's just a matter of how much you have to pay. So there's not a whole lot of difference there. The real dividing line in Maryland is $30,000. So basically most of your cases are going to be in what's called the district court. It's going to They're going to cost about $46 to file the case plus service. So not a bad deal for cases up to 30,000. When you go above $30,000, that's when you get into the circuit court. Those are going to cost a good bit more. You're going to pay $165 to file those, plus service of process. I'm just looking, make sure getting any questions here. Plus service of process. So you can see the pricing jumps up substantially at 30,000. One of the big differences between district court and circuit court is in the district court you have very limited discovery rules. You can't do depositions. You can do very limited interrogatories. When you get up to the circuit court, over $30,000, basically you have everything. You can depose the debtor. You can do lots of interrogatories. You can do requests for production of documents. So that's the big difference there. In our cases, we're not usually doing a whole lot of that. Every now and then we'll get some cases. For example, one of the standards that we will use when we get particularly into the circuit court is we'll see a lot of insurance cases for particularly like workers' compensation audits. We will do discovery and request production of documents, basically requesting all of that debtor's documents to try and prove the audit. And a lot of times that comes in real handy for getting a case settled because they don't have the documents or they don't want to turn the documents over, but it does basically slow the whole process down for them and it makes them take some action. So when you get to the circuit court, you have a lot more of that stuff. District court, 30,000 and down, you don't have a whole lot of that. Now, just looking over my notes because over the last few weeks I've been adding notes as I would come across things. One of the kind of odd things in Maryland in the district court is a defendant does not have to file an answer. They don't have to have a dispute. They don't have to dispute the bill. In a case under $30,000 in Maryland, the debtor has a right to make you put on his case. He can file something and he's actually given this document when he's served. It's called a notice of intention to defend. And all he has to do is say, I wanted to check basically a box that says, I want to defend this case, sign it, mail it back to the clerk's office, and you have to go to trial. You have to bring a witness in and you have to go to trial. He does not have to dispute it. He has a right to see your case. That's kind of an odd thing. Fortunately, not many defendants bother to read what they're served with. So they don't return that little piece of paper. So we don't have that issue too often. So it's a little bit easy, but to be honest with you, if the defendant shows up in court for anything, the judge tends to go, oh, okay, notice of intention to defend, and then we have to bring a witness in for trial, and it will not be virtual. So that's kind of one of the downsides of Maryland. Fortunately, we don't see a whole lot of that. A lot of the defendants that file notice of intention to defend, and you still try and settle the case. So we get through those that way. Now, when you're jumping up to the circuit court, I'd said that's 165 plus service. Your garnishments there are going to be $31 plus service. Most circuit court cases do still get a judgment based on the affidavit, and the defendant would have to file a formal answer. He can't just, file a notice of intention to defend. He has to actually file an answer with a dispute with the court in order to get the thing set for trial. Um, so if they're a corporation, they're going to have an attorney. A lot of times, what we do in both district court and circuit court cases is we file motions to quash. The defendant will file a notice of intention to defend himself, not through an attorney. We'll have the court throw that out. And the case will then go to an affidavit judgment, which is nice. That's a very nice process, that notice of intention to defend process, getting rejected by not having an attorney. Now, when we come to collection, Maryland is actually a very good case to do collections once you get a judgment. They take foreign judgments very readily. It's not a problem there. The advantage is that garnishments in Maryland, you can send them any place. So we mail judgments out across the country. We also can file them in bulk. For example, we have a standard system here that if we have no clue where the debtor's doing anything, we will issue a garnishment on the 9 largest banks in the region. We figure that probably gets, probably 85% of the accounts. It doesn't cost us that much. It costs less than $200 to file those and serve those if they're below $30,000 cases. So it's really not a bad way to do that. I know a lot of places you can't do that, but in Maryland we can. We do them all the time. We, actually have a bulk filing system set up for the 9 largest banks, and we kick those out. Now, an important thing to have is EINs or SSNs. When the banks get these garnishments, they're going to call up looking for, employer identification numbers on the corporations or social security numbers on the debtors. So if you can get the clients to get those to us, get them in their credit applications, that is very helpful. One of the advantages to the, going out of state is Maryland courts have said that if the judgment is originally entered in Maryland and the garnishee is out of state, but they have enough contacts with the state of Maryland that the court can get jurisdiction over them, it doesn't matter where the debtor is. And the case actually arose in a garnishment case. A debtor was sued in Maryland, and a wage garnishment was issued on a large national company, and the debtor actually worked in Texas. And the court was like, well, the large national company, they're here in Maryland, so we can get jurisdiction over them. So they've got to garnish his wages even if he's in Texas. And the same thing goes for banks. So a guy lives in California, banks at Bank of America. I issue the garnishment here in Maryland on Bank of America. They empty his account in California. It works very, very, very well. And oddly enough, because a lot of large businesses are in Maryland because of its proximity to Washington, D.C., a lot of times odd banks around the country will have a reasonable presence here, at least enough that I can drag them into court here in Maryland. When I get a bank that is not sure whether they want to respond to the garnishments or not, I kind of have a little form that I send them. And the form says, okay, these cases typically go one of 4 ways. I'll tell them most banks, they'll answer the garnishment. It's not their money. They have a court order. They don't want to get involved. Answer the garnishment. You're covered. You don't have to worry about liability. I said I'll tell them number 2, the other option is some banks will call me up or email me and they'll say, look, we don't think Maryland has jurisdiction. We're not going to answer the garnishment, but kind of off the record, we don't have anything. Don't waste your time. And I'm like, okay, their attorney calls me up, says, look, we searched, we don't have anything. Let's not waste our time. That's fine. I mean, these banks, they don't care about these debtors. So That's fine. The other option I'll tell them is number 3. I'll do some research. I will not find any decent connections for you in Maryland, in which case I'll let the garnishment die. Number 4, I'll do the research. I'll find some connections with you to Maryland. I'll file for a judgment against your bank, and you'll end up hiring an attorney here in Maryland to try and defend my claim. Right now, I'm running about 50-50 in being successfully bringing those cases into Maryland. I've had some banks fight some. I've had some banks, that have lost, and I've had some banks that have won. So a lot of banks will look at that letter with the 4 options and they'll be like, we don't want to be messed up in this. We'll go ahead and answer the garnishment, or they'll call me up and say, don't waste your time. One of the, interesting things is what we'll do is we'll look for loans. I had a case a few years ago, a bank in Delaware. Now, I don't know if you're familiar with Delaware, but apparently you can't issue bank garnishments in Delaware. So a lot of companies will have bank accounts in Delaware. We think the purpose is so they can be kind of like your offshore account where you can't garnish their bank accounts, so they can kind of hide money in Delaware. And we sent a garnishment over to a small Delaware bank, and they did not want to be subject to the Maryland court's jurisdiction. And they hired an attorney, and we went all through the court system, and they lost. I was able to show that they basically, because they're, right next to Maryland, they had accounts here, they had mortgages here, they had enough stuff, and the court was like, sorry, you're stuck. You got to pay this garnishment. So I don't know if the bank got the money from the debtor or they just had to take care of it themselves. But the bank lost. So some banks win, some banks lose. So that's kind of a nice option that we have in Maryland. We can drag these banks in from all over the place. I had a case just the other day. I issued a garnishment on a small bank in Iowa. Never heard of them. They're in Iowa. I checked, and oddly enough, they had registered here with the state of Maryland. So, they wrote me back saying, well, we don't think we, are subject. And I was just like, hey, I don't even have to send you guys this letter. You're registered here. And a lot of these little banks will register here because of the large corporations that do business with the federal government, and they want to have a presence here to service them. And I think what probably happened with this small bank, they're out in Iowa, there's probably a large corporation out there that has offices in DC area because they're doing business with the federal government. And so they have registered enough here in the state of Maryland so they can service their customer. And so that kind of works really well in the state of Maryland. Like I said, I would have never thought I would have been able to catch this bank from Iowa. I'd never heard of them, didn't know who they were, but yeah, they're here. And I had one also just recently, a credit union, and they're out. They're basically it's like an Air Force Base credit union out in the Midwest somewhere. And sure enough, I showed them the facts, and they decided to answer the garnishment because they obviously have a lot of people in the military who move back and forth between that base and this area. So they have mortgages and other things here in Maryland, probably for these generals and these colonels and stuff who are at that base and then move here and they want to keep their accounts active. So that worked with that one. So that's a place where Maryland is really pretty good. Maryland is really pretty good when it comes to doing out of state stuff. Um, just looking through my notes here. Another really great thing. I see we're running out of time, so I'll wrap it up with this one. We get to maybe get some questions after this. Another really nice thing about Maryland garnishments is they are continuing. There have been many times when I will get an answer from a bank that says we got $1,500 on a judgment that's like 10,000. When the court issues the order on the bank, the order that the court sends to the bank says, pay over the 15,000 that you answered, plus any additional funds that have come into your hands since you were served with the garnishment. So hopefully the bank is freezing the account and collecting money. And sometimes that works really well. We'll think we got $1,500, and then the bank will send us a check for the entire judgment because money continued going into that account after the bank answered. It also works really well for people who have direct deposit into their bank accounts. So we'll just basically, they have direct deposit coming from whatever entity it is, and we'll just, sit out the 30 days, get the court order that says give us our money plus everything else, and we'll get that. And I can see we're at 3:28, so I guess we've actually run a tiny bit past the 20 minutes. So any questions?
I'll start with a question. If anybody else has a question, please put it in the Q&A. Peter, I know that your background includes drafting the rules in DC to process collection cases,
Yes.
right?
Correct.
So have you found in your experience that in election years, such as our present year, that there are any changes that need to be made to that process given the election year?
Well, DC is a unique thing in that Congress has to approve everything that they do. They're not really a standalone entity. And the rules come down from the Court of Appeals, so there is no election oversight. The judges in Maryland, in DC, are appointed by the President of the United States. So it's kind of a different thing. So the rules are actually handled by the courts and the chief judges in the Court of Appeals in DC. And yeah, I did years ago. They had decided that they needed rules for collection cases because they were years behind in their dockets. And so they called a bunch of, attorneys in who handled what they call collection cases. And I was on that panel with the chief judges. There were maybe 6 attorneys or so, and the other guys were all retail. And we basically drafted a section, and it was a separate calendar just for collection cases, where basically instead of taking years to get through the process and having multiple hearings and, setting expert hearings and expert notification dates and all that, it's basically a very quick, takes about 5 or 6 months, 2 hearings, and you get to trial. And that was really nice working that through the system. And the actual definition for collection cases was actually my definition. They were all sitting around there scratching their heads going, well, what would be a collection case? And I said, well, kind of hard to determine, but they would be, they would all be a case for a liquidated amount. There's not like personal injury damages, and they're all for liquidated amounts. And that's actually when they wrote the rule, that's actually the definition that went in there. Cases for a liquidated amount. Because that's the way collection cases are. We get our $1,000 or we don't. It's not like personal injury cases where it's like, well, how much is a hurt knee worth? How much is pain and suffering worth? We don't deal with that. So yeah, so the election stuff doesn't really come into play in the DC. And in Maryland, it is what it is. Maryland is moving in a pro-debtor direction, but it's not too terrible yet.
Well, I would imagine that unique twist of the notice of intent, you would consider a blessing that most people don't read that, because if they did read that, they would want their day in court, and your court system would be really clogged up with people who, especially on consumer accounts, right?
Yes. And when they first came out with that rule, Mr. Kudish, who long since passed away, but he was like, oh, this is going to be the end of our practice, because they're handing the debtor the answer. All you need to do is sign it and mail it back to the court. Yeah, well, they're not reading those things. Fortunately.
Thank goodness.
Thank goodness.
Thank goodness that is fortunately.
Yeah, thank goodness.
I think that's some really great information about DC and in Maryland. If anybody has any additional questions, please put them in the Q&A, not the chat, the Q&A. And while that's happening, Umberto, if you could just monitor that.